Today's presentation is going to be given by Mr. Terry Salazar. Terry is an attorney with Quilling, Sealander, Lowndes, Winslet, and Mosier in Dallas, Texas. His practice areas are construction and surety. He was a Notre Dame graduate in 1976 and got his law degree from the University of Texas. Terry represents owners, contractors, subcontractors, and surety companies in all phases of construction contracts. He represents clients in dispute matters in both state and federal courts. His past experience, he was senior VP and general counsel of a large international steel fabricator. He's past chairman of the DBA construction law section. He's a former U.S. Army JAG and procurement law attorney in the office of the general counsel for the NSA, so make sure you don't say anything too loud. And he's also been the author of various legal articles and publications which are for the construction industry. He's a frequent lecturer to the construction industry, including the Associated General Contractors National Project Managers Course. He's past chairman of the City of Dallas Building Code Advisory and Appeals Board. And I'll now turn this session over to Mr. Terry Salazar.
Thank you, Bob. Okay. Well, I appreciate the kind introduction from Bob. When I was asked to do a presentation this year, I was told that this topic was of key importance to erectors, especially in today's economy. And I asked Bob, I said, Bob, can you give me some direction on how you want me to focus the presentation? What level do you want me to try and gear it towards? Any tips you can give me would be great. He said, Terry, he says, I'm going to give you my one golden tip for presentations. He said, just remember, when you're promulgating your esoteric cogitations, beware of platitudinous potterosity. I said, hold on a second, Bob. I said, let me get my dictionary out and look it up. And when I looked up the words that Bob had communicated to me, what I realized he was saying was that when you're communicating your ideas, keep it simple. And that's what we're going to try and do this afternoon. Is we're going to take a couple of very important, I call them lifeline issues for the subcontractor community, and we're going to focus it on the erection subcontractor community in terms of how are you going to be able to deal with making sure that you're able to collect your changes and that you're going to be able to get paid your retention with final payment. Now, these are probably the two greatest areas of payment exposure for erection subcontractors, change orders and retention. And what we're going to do is we're going to look at some tools that you can hopefully take with you today to improve, it's not a guarantee, but to improve the likelihood of collecting a higher percentage of your change orders and getting paid your retainage sooner than you may have been experiencing in the past. Now, here's some of the basic problems that you encounter during your performance of work on the project. Okay, converting changes into written change orders, getting payment for the changes during the course of the project as opposed to at the end of the job. We all know what the success rate is when you have to negotiate your changes at the end of the job after your work is completed, and then dealing with retention being held for an unreasonable period of time after your work is completed. Okay, so what we're going to do is we're going to try and better understand what are the causes of these problems that you encounter. I'm going to provide you some tools for better management of the change orders and retention. And most importantly, I want to give you some strategies. These are strategies for you to use on a project-by-project basis, but you've got to tailor these strategies for each unique project that you're going to be working on. Okay, these are the topics we're going to cover. This is in your outline. It's the key contract provisions affecting change orders, the submission of change requests, the use of change order logs. How many of you all actively use change order logs as a project management tool? Okay. How many of you that use them as a project management tool review them and update them on a weekly basis? Okay. If you're not doing it at least on a weekly basis, you're not taking care of business. Okay. We're going to talk about how to push the change request that you've submitted to resolution. You submit that change order request, that change proposal, and it seems to fall into a black hole. Months go by, you never hear anything about it. What's the status? You know, you're left at the mercy of your upstream contractors. We're going to talk about some things that you can do to gain control over that process and to push the change request to resolution. And if need be, we're going to talk about timely conversion of change requests to claims. I can tell you that I've pursued millions and millions and millions of dollars of change requests on behalf of steel subcontractors and erection subcontractors. And this last item ultimately was a key catalyst in getting things off high center. And one of the things that we're going to talk about is this fear of referring to a change request or a change proposal as a claim. Okay? But when you see how this concept fits into the structure of your contracts, then you'll understand that this is a very important tool at your disposal that many of you are not using, and you're suffering the consequence of having months and months go by without any resolution. Okay, we're going to talk about a couple of key ideas with regard to retention. We're going to look at contractual retention provisions. Okay, some of the different types of retention provisions that you may encounter in your contract documents. We'll talk about how you can seek timely reduction or release of retention. And then when it comes to final payment, what can you do to possibly accelerate final payment to get it quicker than you've normally been getting it? Okay, let's first talk about some key contract provisions affecting change orders. Now, about 3 years ago, I did a presentation to this annual convention talking about contract provisions, contract clauses. And I used an acronym in my presentation, RTC, not the Resolution Trust Corporation, but read the contract. Okay? If you don't read the contract, you're going to be lost. And then I emphasized it even more so by saying, no, change that acronym from RTC to RTFC. Now you're smiling. What does RTFC mean? Read the full contract. Now, what do I mean by the full contract? If you're entering into a subcontract agreement, and I'm going to use a typical scenario where, as an erector, you may be working for a steel fabricator who is the steel contractor to the general contractor, or is the trade contractor to the construction manager. So you've got several layers of contract documents that you've got to deal with. Okay? The first one that you have to look at is the owner-contractor agreement. When you're out on a project site and somebody's telling you you've got to go out and do something other than what you had planned, that this is a change, and you've got to go out and do something that you're going to have to submit a change request for, you have to know whether or not the party or the parties that are telling you to go do that work have the authority to make a change to your scope of work. And the first place you've got to look at is in the owner-contractor agreement. Who has the authority to issue changes? Are there any written limitations in terms of a dollar value, level of authority? I can tell you that there have been numerous instances in the past on projects where you have an individual who's not authorized to commit the owner or bind the owner to a change, who issues an instruction that's going to cost $500,000. And the steel contractor's ready to go out and do it, and they expect their erector to follow along in suit. And you go back and you look at the trail of authority, and guess what? Who's the person who's issuing the directive that's considered a change? It's the engineer of record. It's a major change in a revision to a shop drawing. It's going to affect not only the fabrication, but it's going to affect the erection. It's going to make it more expensive for you to erect that steel. And guess what? The EOR is not a person who's authorized to issue changes under the owner's agreement. There was a project that was being done in Denver. It was an expansion of their convention center where the engineer beefed up the connections, and it was going to cost $750,000. And the subcontractor stopped and said, wait a minute, this person doesn't have, this engineer of record doesn't have the authority to issue the change. Went back up to the general contractor and said, has the owner's rep ratified this directive? Please confirm that we're directed to do this as a change. The next thing you know, we have a meeting with the owner's rep, the GC, the EOR, the steel contractor, and the erector. And the owner's turning to the engineer and saying, do we need these beefed up connections? The engineer goes, well, you know, I'm kind of a belt and suspenders type person. And the owner says, we don't have $750,000 to pay for this as an extra. Will it work as originally envisioned? Yes. Go back to it. Now, what if they'd pushed those changes through the shop, that steel had hit the job, and it costs more money for you as the erector to erect it? And then somebody stops and says, well, we're entitled to be paid as an extra. Look at the contract documents to determine who has the authority to issue the changes. Now, there's an old expression, the devil's in the detail. And we're not just talking about detailed drawings. We're talking about the details that are in these contractual agreements. If you're going to be able to successfully pursue changes, you've got to understand, first and foremost, how do you present these changes? Okay? If you don't present them in the proper format, all you're doing is delaying your recovery. In the owner-contractor agreement, typically now, you're going to see specific provisions that identify what types of costs you're eligible to claim, whether or not you can have your superintendent, for example, included as a direct charge, or whether that's got to be absorbed as part of your 10 and 15% markup for overhead on the direct costs. Everybody following me? In other words, you have to identify in the owner-contractor agreement, if it's the owner who's paying for the change, how are the costs able to be submitted? What are the limitations on the costs? Do you have fixed markup amounts in the owner-contractor agreement that limit your overhead to 5%, profit to 10%, or is it a combined 10% markup for overhead and profit? You need to know that up front, as opposed to just, you know, submitting your typical markups that you would ordinarily ask for, 10 and 15 or whatever. Okay. What are the rules on the submissions of change requests? Okay. Once you have a directive in some format that's been given to you, it might be that you receive downstream a copy of an architect's supplemental instructions and you're asked to price it. How many of you seen provisions in these owner agreements that say that if you don't submit your change proposal, if the contractor doesn't submit their change proposal within 5 days, it's presumed that it's a no-cost change? Okay? And you're second or third tier downstream, you've got to know what are the time limits for submitting these in order to make sure that you don't waive your right to additional compensation. Change directives versus change orders. Okay. Now we all know that ultimately you get paid via change order, right? But more and more we're seeing that the changes on projects are issued in the form of written instructions or change directives. Now, in the owner agreement, you need to identify what are the requirements for a written change directive from the owner's representative in order for it to be a binding change directive. Now, why might that be important? Well, it could be the key to you getting paid for this change order work while you're still doing the work even though you don't have an executed change order yet from the owner and the contractor and the fabricator. Let me give you an example. Several years ago, when they were building Heinz Field in Pittsburgh, they had a major change to the steel. They added a bunch of steel, and it was going to be about a $3.5 million change to the steel contractor. The owner's construction manager issued a change directive, directing the fabricator to go out and purchase this extra steel and get it into the shop for fabrication. The fabricator gave a preliminary notice of a $3.5 million cost impact. And the construction manager said, well, we don't think that that's a fair price, so we'll have to deal with negotiating the cost of that down the road. Well, we went and looked at the owner construction manager agreement and said that for change directives, the construction manager had to indicate a reasonable value for the change directive if there was not agreement in advance on the value of the extra work. And more importantly, that the contractor could bill on an interim basis up to that estimated value. So when that was brought to the attention of the construction manager, and the construction manager on that project happened to be Hunt, and Hunt was told, this is not a valid change directive because you don't have any assigned estimated value. We can't bill against this change directive. Hunt came back and said, okay, well, we're just going to put a plug value in of $100,000. And we said, no, that's not a reasonable estimated value. We're not proceeding with the change, and every day of delay is a day of delay that the owner's going to have to absorb. And they came back with, I think it was 1.7 or 1.8 million. But at least there was some substantial reasonable value there assigned to the change directive that the steel contractor was able to bill for. So my point is, understanding what these provisions are with regard to changes and change directives are very important in terms of you being able to get paid for some or most of the cost of these changes, even though you don't have an executed change order. Now, here's a key provision that sometimes gets lost in the shuffle, and that's under these contract documents, you're always going to have an obligation to continue performance even though you don't have agreement on the value of the change. Okay? You'll find it either in the changes provision or in the disputes provision, but you cannot refuse to perform because you don't like where the pricing's headed on this change directive. Okay? You will have an obligation to continue performance. Now, this is a sample provision from a contract that allows for interim change order payments. And if you notice, it talks about how the contractor may invoice and the purchaser may pay actual cost properly charged and documented, but subject to final adjustment before at the conclusion of the performance of the changed work. Okay. So this is just one example. This is from an industrial project. It was a power plant project where the owner acknowledges that you can bill for changes even though you don't have final resolution of the cost in the form of a change. This is a provision from the AIA contract documents, the A201, general conditions. It explains the construction change directive is a written order prepared by the owner, signed by the owner, directing a change in the work prior to agreement on adjustment. The owner may, by construction change directive, without order changes in the general scope of the work. Okay, so here a construction change directive is defined. Now, what about getting paid for construction change directives? In the AIA documents, it says upon receipt of a construction change directive, the contractor shall promptly proceed with the change in the work and advise the owner of the contractor's agreement or disagreement with the method, if any, provided the change directive providing for determining the proposed adjustment in the contract sum or contract time. But here are different pricing mechanisms that can be used in that construction change directive. Now, Here's where we get to the good stuff, 7.3.8. Pending final determination of the total cost of a construction change directive, such changes in the work shall be included in the applications for payment accompanied by a change order indicating the parties' agreement with part or all of such costs. Okay. My point here is one of the most common forms of construction documents in use, the AIA contract documents, the owner agreement, general conditions, contemplates being able to get paid for construction change directives while you're trying to resolve the final pricing. Okay, let's talk for a minute about whether or not you can get paid for verbal change orders. We all know that your contracts say all change orders have to be in writing, all change directives have to be in writing, right? The first point I want to make is there's really no excuse for you while you're on the job site. If you receive an instruction that you believe is a change to your scope of work, there's no excuse for you not getting it reduced to something in writing. Even if it's as simple as taking a piece of paper and a pen and writing down that the fabricator's representative or the general contractor's general superintendent directed us to do A, B, C, and D. We consider this to be a change to our scope of work. You hand it to the person who directs you to do that change, and you ask them simply to sign it, acknowledging that that's what they told you to do and that they understand that you consider it a change. It doesn't contain any wording saying that they agree it's a change, right? But one, you've reduced his verbal instructions to something in writing that he's going to initial or sign. And you walk over to your job site trailer or to his job site trailer and you make 2 copies of it. And you give him one and you keep one. And then you follow up with it either at the end of the day or the next day, but you've got something in writing that confirms a directive to do a change. Okay, that's great in theory, right? But sometimes our foremen that are out there on the job sites, they're just building the work. You know, paperwork's not their strong forte. Well, if you have a pattern of conduct or a course of dealing on a project whereby you're given verbal instructions that are changes to your work, you go ahead and you perform that extra work, and then you submit an invoice for payment, and you get paid on that. The law says that you have a course of dealing that develops whereby the written change order requirement in your contract is essentially been modified by the course of dealing or the behavior of the parties, okay? So what you have to do is you have to reduce it to writing, but if you don't, there is a safety net. Don't rely on the safety net. You know, sometimes your ability to document the course of dealing is not very good, okay? Always get it reduced to writing. Now, let's talk for a minute about changes provisions in your agreement between the general contractor and the fabricator that's incorporated into your erection subcontract. How many of y'all, when you get your subcontract from a fabricator, get a copy of the owner-contractor agreement and the general contractor's agreement with the steel fabricator and review those? Okay, if you're not doing that, shame on you. You need to do it. One of the, yes?
It's very difficult if someone says to do that. One thing we'll do is say subject to review for the clause and there's that effect. That's not a very good way to open the door. Or at least it sends back to my customers where acknowledging I will not review their contract. You can't say something like this is a contract. You need to come together. It's very difficult to have those two entities stand up.
Okay. Everybody hear his point. He's saying that sometimes it's very difficult to get your customer to provide you with these copies of these agreements. Well, you know, I review probably, I don't know, 10 to 15 sets of contract documents a month. I've yet to see one in the last 2 years that doesn't have this typical flow down language that says the owner-contractor agreement is incorporated into the steel fabricator's subcontract. And I've yet to see a steel fabricator subcontract to an erector that doesn't say that the contract documents in their contract with the GC are incorporated into the erector's contract. Now, it's a very simple question. You ask your customer, whether it's the general contractor or it's the steel fabricator, do you want me to comply with these various contract documents? If you do, I have to have a copy of them. I can't remember all that stuff. And don't tell me that I can come and sit in your job site trailer with a pen and a legal pad and take notes. Now, as Bob told you in the introduction, I do a presentation to the AGC's National Project Manager course 2 or 3 times a year. It's a longer session. It's about 5 hours, and it's on contract provisions and legal issues affecting construction. And the one thing I always tell them is they absolutely, positively need to give copies of all of these contract documents that they're incorporating into their subcontracts. They need to give copies to their subs. Okay? So, I know that what you're saying, but it's real simple. If they want you to comply with these upstream provisions, they have to give you a copy of them. And here's the point, is that until you get a copy of these upstream documents, you don't know whether you've already been, put in a 6-foot hole and it's just a matter of people putting dirt on top of you. What do I mean by, is there a single changes provision in the contractor-subcontractor agreement? Does the contractor's agreement with the fabricator say, all changes will be paid for out of the money that's received from the owner? And that the contractor will pay the steel contractor when they've received the money from the owner for those changes. Well, who here has been on a project where every single change that they had to do in that job flowed from the owner? Where there were no changes caused by the late performance or the defective performance of other trade contractors, or where the fabricator made some mistakes and you had to do some field correction. That's a change, right? Here's where, up front, you have to look at these documents and you need to get your agreement with your customer to reflect the fact that the owner is a possible source of changes, that the general contractor is a separate potential source of changes, and if the general contractor or its other subs are the source of change, what is the terms of payment for those changes? Hopefully you're not going to agree to wait until the owner pays, because you'll be waiting until the cows come home. The owner's never going to pay on a change that the contractor is responsible for. Like if the embeds that his concrete sub installed are screwed up and you've got a bunch of changes that you've got to do when you put your steel up, is the owner going to pay for that? Absolutely not. Okay? So recognize that the contractor needs to have an obligation to make payment on changes separate from the owner. Okay. Schedule changes due to delay, payment for the costs of delay. The classic, what we refer to as the no damages for delay clause, where all they want to give you is a time extension if your work is delayed on the project. Well, what you have to do in evaluating this provision is decide, number one, can I live with it? If I'm delayed, if it's critical path delay, where I've got idle equipment and standby labor costs, am I willing to eat that? Number two, if you're only willing to absorb that up to a certain amount, you've got to modify the provision and have a cap put on, where you say, we'll go ahead and do that, not to exceed maybe 1 day a week, 10 days total during the project. And if it's a true critical path delay to your work, then the time extension, if it's delay caused by a predecessor trade, a time extension, the remedy you're agreeing to, it may not be available. Classic scenario, you're going to be erecting steel on a concrete slab, and the concrete slab gets screwed up. It's late being placed. The contractor's behind schedule. He can't give the steel contractor or the erection subcontractor a time extension because he doesn't have any time extension from the owner to give you. So what happens? You're being accelerated. Put in these provisions, in the changes provisions, that if you are accelerated, that you'll get paid your costs of acceleration. Okay? Don't leave it to chance. I mean, there is a substantial likelihood on some of your projects that you're going to be delayed and then you'll be accelerated. Why not just go ahead and address that up front before you sign your subcontract and have a revision made that acknowledges liability of the upstream contractor for acceleration costs? Okay, now, with regard to schedule, one of the things that you need to do is you need to make sure in your subcontract with the fabricator, so this is maybe the second tier subcontract, you incorporate an agreed baseline schedule. What do I mean by that? Well, my experience is that at least 50% of the time, there's just a general reference in the fabricator's subcontract with the general contractor to a project schedule. There may be a specific date associated with a particular schedule. Sometimes you'll see a bar chart schedule attached. Sometimes you won't. But my point is that in your subcontract with your customer, you need to make it clear what your baseline schedule is, because that becomes your yardstick for measuring changes to the schedule. Don't let there be any confusion, okay? Make sure that you've got a specific schedule incorporated. Now, the second part of the equation is you need to follow up with the general contractor and confirm by looking at the general contractor's project schedule that it's consistent with what your schedule with the fabricator is. Okay? I was on the phone a couple of weeks ago with a client where the fabricator was dealing with one schedule with the erector, and the general contractor had a completely different schedule time frame for the steel work that they were operating with. And there was months difference between the two. Now, you ask yourself, how can that happen? But it's because people are not going back and looking and taking the specific schedule incorporated into the erection subcontract and making sure it matches up with what's in the project schedule. Second thing, with regard to the project schedule that the general contractor is maintaining, y'all are the primary people that are attending these subcontractor meetings on a weekly basis. You ought to be getting copies of the general contractor schedule update. They're not going to want to give it to you, but you're entitled to it. It's a part of the contract documents, okay? The best of all worlds is if they'll give you an electronic copy. That'll happen about once in 100. At least get a paper copy of your portion of their schedule update so that you can track and see how are they managing your work, how are they projecting it out. You know, avoid surprises. The other thing, though, is that ultimately when you submit your change proposal, if there is a schedule impact to your work and you have to ask for a time extension in order to not be on the hook for liquidated damages, many times these agreements will have a requirement that says that you have to submit schedule analysis to support your request for a time extension. And if this is going upstream to the owner, that schedule analysis has to be based upon the contractor's project schedule with the owner. Okay? You with me? So that's another reason why, how can you complete your change order request submission requirements if you don't have a copy of the most recent schedule update that the general contractor's generated, so that you can then show the impact to your portion of that schedule as part of your request for a time extension. Okay? Now, in your subcontract with the fabricator, this is rarely done, but it should be more often. You need to attempt to address the situation of late steel deliveries specifically. Are you going to absorb late steel deliveries? How do you distinguish between steel that's late and late deliveries that cause critical path delay? There's float in these schedules, right? But you're not planning on having your equipment and your men standing by and the fabricator burning up, your equipment costs because they're late with steel deliveries. So you need to address, is this commitment, these deliveries by sequence or by priority, are they firm commitments? If they are firm commitments and you're committing to having your men and your equipment, they're ready to erect the steel, there's a cost that's incurred when the steel is late. You need to talk about it and address the issue as to at what point does the fabricator pay for late steel deliveries. Once again, acceleration costs. Address it in your agreement with the fabricator. Now, this is a change if you're accelerated because the fabricator is late. Is that change going to be paid by the contractor or by the owner? No. It's coming out of the fabricator's pocket, right? How many of you in your typical subcontracts have specific language that addresses how you invoice for changes that aren't going up to the contractor or the owner? Or what's the time period that you get paid for these changes that are the responsibility of the fabricator and that don't go upstream to the contractor or to the owner? This is sort of a subset of it, is address in your contracts who's going to, what's the agreed protocol for submission of T&M tickets and for timely review of those? How many times do you do field correction work and it seems like it's months before you can get the attention of somebody at the steel fabricator to process them so you can bill and get paid for them? Address it up front. Say that there'll be a monthly review of T&M tickets for invoicing. And that's a monthly review with the steel fabricator's project manager. There should be somebody that's daily approving these T&M tickets. And by approving, we're talking about confirming that the equipment and the manpower that is on that ticket actually was present, okay? And a separate provision regarding billing and payment by the fabricator. Okay. Now, one of the things that you encounter on these projects is the tendency for people that are upstream to always blame the owner. They say, submit your change proposal, go ahead and price it up, and we're going to submit it to the owner. And what you have to be careful of is, what if there is an issue that causes a change in your work that the owner's not responsible for? Do you commit or agree when you're submitting these change order proposals that you're going to characterize this as an owner-responsible change? How do you know that the owner's responsible for the late changes to the steel that are causing late deliveries, that are causing your work to have to be accelerated because of the late deliveries? Is it really an owner change? Or was there an error in the shop drawings by the detailer that caused late approval of those shop drawings that then caused late delivery of steel. And if you go ahead and identify it as an owner-responsible change, it's going to be much more difficult for you later to back up and say, oh, I didn't mean that. It's really your responsibility, fabricator. So when you're submitting a change proposal, ask yourself, do you have enough information to identify who is ultimately responsible for payment? Is it the owner, is it the contractor, or is it the fabricator? And until you have enough information to lock it into just the owner or just the contractor, you have to look to your primary customer as the responsible party for payment. And then it's up to them to demonstrate to you why it's not their responsibility and it's somebody above them. Because what happens if you agree to it being an owner-responsible change, and then 8 months later, there's ultimately a determination that the owner isn't responsible? You're in a meeting with the owner, the contractor, the fabricator, and the contractor says, well, okay, I guess, you know, the owner's not responsible for that. Then you turn to the fabricator and you say, are you going to pay me for it? And they go, well, read your subcontract. It says that on owner-directed changes, and you said you agreed this was an owner-responsible change, that you're limited to getting paid what we get from the owner. We didn't get anything, you don't get anything. Okay. Submission of change order requests. This is pretty straightforward. What you want to do is you want to make sure you comply with the technical contractual requirements for change proposals, the format requirements. The cost breakdown should only have allowable costs. Okay? Go to the contract documents and identify what are the allowable costs. We've talked about schedule analysis to support your time extension request. Are you on a project that requires certification of costs? Who here is doing work on a federally funded or a federal project right now? Okay. If you have a change that's going to be for $150,000 and you submit your change proposal upstream, do you have a certification requirement? Do you have a certification requirement for change requests on? Right. On federal projects, for changes, it used to be $50,000. With inflation, it's now up to $120,000, I believe. You have to certify when you submit your change request that the cost and pricing information that you're submitting is current, accurate, and complete, and that it represents the costs that the government is responsible for. The contractor has to certify that to the government as part of their change order submission. The contractor expects the similar certification, and these contractors ask for these certifications from their subs and their second-tier subs. So understand up front, do you have a certification obligation with regard to certain dollar threshold change requests? Understand what is the significance of that certification. If there's incorrect information and you were negligent in including that incorrect information, you may lose, under the False Statements, False Claims Act, you may lose entitlement to payment for the change. You may be subject your company to a forfeiture of the payment of the billing where you invoice for that change as a part of your pay app. I mean, some pretty serious stuff. So understand whether or not you have a certification requirement and what is the significance of it. Okay. This is probably the single greatest deficiency that I see with regard to change submissions that causes delay in the processing and payment of change orders. Everybody will price the labor, the equipment, total it up, send it in. And you read the letter of transmittal, and it says, attached is our pricing proposal for COR number 271. That, you know, and there's no description, no narrative explaining what's the significance of the change. You know, what's the impact? Include a narrative. It doesn't need to be long. You know, was that Joe Friday used to say, just the facts? Tell a story as to what, how, when, and why the extra work is a change. Recognize that there's going to be at least probably 2, 3, 4 sets of eyes reviewing this paperwork. And they're not as intimately familiar with the detailed drawing that you're basing your pricing proposal on. They don't understand why a change to, you know, the location of landings causes you to incur additional costs. So you got to tell them that. Okay? Tell a story. I guarantee you, these change orders will get processed faster if you tell them why it is a change up front. We've talked a little bit about, is the change the responsibility of the owner, the contractor, or the fabricator? Okay. The characterization of the change will affect your payment options. If you don't know the facts sufficiently to, with a high degree of certainty, say it's the owner's responsibility, then don't pigeonhole the claim, okay? Don't pigeonhole the change request. How many of you, when you submit your change proposal, ask for a copy of your customer's transmittal of your change proposal as a part of their change request to the GC? How many of you get a copy of the GC's submission of the change request to the owner? Your contract says that your entitlement to payment, to finally getting the dinero for this change, hinges on the ability to get payment from the owner. All of these documents are part of the packet that the owner is going to review and evaluate. Is there any reason why you shouldn't ask for a copy of this? Okay. First of all, if you do ask for a copy of it, it's going to tell you how long did your change order request sit on the fabricator's desk and on the general contractor's desk. Additionally, it'll tell you whether or not there's more information being shared upstream that you don't know that may have an impact on whether or not you've been given the full story with regard to this change. As part of your record keeping, ask for copies of these transmittal documents, okay? Now, change order logs. This is a key project management tool. There's some things that I've reviewed hundreds of change order logs over the years. Some of them very elaborate spreadsheets, others just manual, forms. Here's the point with regard to changes, okay? Update it weekly. If you're not updating it weekly, how can you effectively manage where your changes are? Have you submitted something in writing for this extra work? Okay, if you have, when did you submit it? Do you include suspense dates for when you're expecting for that change request to have been converted to a change order? You submitted a change proposal on January the 15th. It's now March the 9th. And you don't have any idea what the status is. If you're at least reviewing your change order log on a weekly basis and you establish a suspense date of 60 days, you know, if you review on a Friday or a Monday, you know, okay, next week is March 15th, coming up on that 60 days. And if it hasn't happened in 60 days, then I need to do something to move it along. But it's keeping those change proposals on your mind and flagging when they should become critical. Do you have in your change order log a column that indicates the work has been completed? You submitted the change proposal, it hasn't been converted to a change order yet, you went out and did the work, you kept track of the costs, the work is complete. Do you have a column in your spreadsheet that says update change proposal with actual costs? What did you submit initially? You submitted estimated costs, right? Do you have a duty to present actual costs? Yes. Typically, when you haven't gotten a change order on a lump sum basis in advance of the work, 9 times out of 10, they're going to want you to demonstrate the actual cost of the work, and that will be the basis for payment, is the actual cost of the work. If you don't submit an updated cost proposal based upon the actual cost of the work, and it's a public project, then depending upon the laws applicable, you may be exposing yourself to some problems because you're representing estimated cost in trying to secure payment for the change, and you haven't submitted actual costs. Okay. Pushing the change order to resolution. How do we get this change order request off of High Center, and how do we move it along? Well, I submit to you that 30 days is the starting point. You can choose, based upon your relationship with your customers, whether you want to use 30 days or 60 days as the point where a red flag should go up. Okay? But realize that in your contract documents, especially the owner-contractor agreement, there might be a provision that imposes a duty on the architect to review change proposals and to submit a preliminary determination within a certain period of time. Okay? Do you know that? Have you read the owner agreement? Once you've flagged in your change order log that 30-day or 60-day time period and you hit that flag, send something in writing upstream. Ask what the status is, okay? Document your effort to get an update. If nothing else, use an email, okay? But send something in writing to ask what's the status. And when you send that request in writing, you ought to include a statement that says that it's been outstanding too long, and that if it doesn't get reviewed and addressed promptly, then we're going to have to pursue this matter as a disputed change request. Okay? Because that ultimately is your trigger. Is that you have to realize that at a certain point in time, if there's been no agreement after 60 days, then there must be disagreement. And what's another word for disagreement? A dispute. And you've got in your subcontract and in your owner-contractor agreement dispute procedures. Okay? So let's look at these contractual provisions that tell us what the dispute procedures are, and then let's go ahead and start labeling unresolved changes as disputes. If you wait until the end of the job, you know, I have this metaphor I use. It's called the pendulum of negotiation leverage. Okay? Your leverage in negotiating these change requests is virtually nil at the end of the job. During the course of the job, you can use the disputes provisions, the disputes procedures as a pressure point upstream with the fabricator and with the contractor. They would much rather just put it over in the corner and ignore it because it's not their money. Or they may have some money involved, but your money is your money, right? You've got to push. If you don't push, you're going to get overwhelmed. Okay. Now, here's an example of a very simple provision that addresses the owner being identified as the decision maker on disputes. And this happens to be on a federal project, so you'll see that there's a reference to the contracting officer. But in the first paragraph, it's talking about how the subcontractor acknowledges that there's going to be certain decisions and factual and legal determinations made by a contracting officer, including but not limited to decisions or determinations as to the quality of the work, suspensions, or changes. Now, down here in the last paragraph, it talks about the subcontractor expressly acknowledging and understanding that any right of the subcontractor to receive any payment under the subcontract shall be coextensive with the contractor's right to receive reimbursement for such payment under the general contract. Subcontractor expressly waives any claim to any payment in excess thereof or on a basis for payment different from the foregoing. In plain English, you only get what I get from the owner. And it also references, because it's a federal project, that this provision is intended to affect your rights under the Miller Act for pursuing a payment bond claim. Now, let's assume for a minute that it is an owner-responsible issue, and it's been outstanding for 6 months. In this particular instance, since it's a federal project, you can go and say, we want a contracting officer's decision on this outstanding change request. Let's get the clock ticking under the disputes procedures. How long does a contracting officer on a federal project have to make a decision on a dispute? 60 days. Has to issue a written decision within 60 days, or at least by that 60-day deadline, tell you a specific date when they will issue a decision. So you've submitted, you're doing the steel erection, you're doing it on a, let's say it's a new hospital, and you've got a change proposal that you submitted January 15th, 2012. The job's not going to be completed until July 2013. Are you going to let the general contractor just kind of keep that change proposal, if it's unresolved, just part of a stack that keeps growing? Why should you? March 15 comes, no action on that change request. Go to the general contractor and you say, hey, there must be a dispute. It's not been pushed. Half the time it's because the general contractor sat on it and has ignored it. May not have even pushed it upstream, but if you say, we're going to insist that you request a contracting officer's decision, they're going to say, well, wait a minute, we haven't even submitted it. Or if they have, well, you know, they've only had it for 15 days. The point is, when you say, because I'm locked in under your contract to what the owner does and the decisions of the contracting officer, I'm going to push to get a contracting officer's decision. I'm not going to wait until the end. And if you refuse to push it, if you refuse to exercise the rights under the contract, then guess what? You're basically waiving the requirement that I have to look to the owner. Okay? I can't tell you how many times when we've had this conversation with the general contractor, all of a sudden, it's like it got moved from the back burner to the front burner. And the vast majority of the time, they become incentivized to deal with this issue, to get it resolved. Okay? Sometimes it does get resolved, sometimes it doesn't. Okay? But the point is, if you've got a change order that's out there that's pending, a change request, you may have to convert it into a claim and seek a written decision on the claim. So you have to go and look at the contract documents to say, who's the gatekeeper? Who's the person who makes that initial decision? We saw in that previous clause that it was the contracting officer, right? Okay? And we know that we can put the decision maker on a clock, right? Well, this is a provision from the EJDC set of contract documents, okay? And this has to do with an engineer's decision where the engineer of record is the person who's making the initial decision. All claims shall be referred to the engineer for a decision. It's required as a condition preceding to exercise by owner or contractor of any rights or remedies. In other words, you've got to go through this portal, through the engineer. How long does the engineer have to make a decision? The engineer will review each claim, and within 30 days after receipt of the last submittal of the claimant, take one of the following actions in writing: deny the claim, approve the claim, or notify the parties that he's going to abstain, that he can't make a decision. And what's the effect of the abstention? It's essentially a denial. But what's the point here? The point here is, if you're an erector on a project that's got this form of document, you go to the contractor and you say, it's been 3 months, no action by the engineer. Submit a request for a written decision from the engineer. Characterize this as a claim. We want a written decision. Let's put the engineer on the clock. We don't want to wait until the end of the job when people are horse trading and my dollars get lost in the shuffle. How do you try and protect the integrity of your changes? First and foremost, try to avoid them being bundled up with other trade contractors, okay? Especially if you're at the end of the job. Because what happens? If you're part of an omnibus claim that's submitted at the end of the job by the contractor to the owner ultimately, 9 times out of 10, is going to make a lump sum settlement with the contractor for all those claims, all those changes. And what's the contractor's favorite method of doling out the money? Pro rata basis, right? So if you had 10% of the total cost of the claim, the contractor is going to want to give you 10% of the recovery. But what if your 10% was 100% owed? And you're mixed in with some other subs who've got a lot of fluff, or who, we're just hoping to get something. In effect, what happens is that less meritorious claims dilute the value of your claim. This is why I encourage you to look at utilizing the dispute process during the course of the project, when you have more of an opportunity to have your issue handled on a standalone basis, as opposed to at the end of the job, when it's going to get bundled. Okay? I mean, represented a contractor on a project in California where the steel represented approximately 30% of the total claim, and the dollars were hard dollars. You had the general contractor had a bunch of general conditions and this and that, and other folks had unabsorbed overhead that they had as a part of their claims. Settlement with the owner, and there's a 55% recovery. And the general contractor said, we want to pay you your pro rata share. And the steel contractor said, no, not going to accept it. Because early on in the process, the steel contractor asked for its claim to be submitted on a separate track, and the general contractor refused. And the steel contractor said, okay, you know what? If you refuse us, we're telling you right now, we're not going to be bound by some pro rata distribution, and we'll look to you for the difference. And ultimately, because of the insistence early on of being treated on a standalone basis, the general contractor ended up paying that steel contractor a substantially higher percentage, including a few dollars out of their pocket, out of their portion, in order to resolve the steel contractor's claim. But they wouldn't have been in a position to obtain that result if they hadn't early on said, we want to exercise our right to pursue this claim under the disputes process as a standalone claim. Not only that, but bigger claims take longer. It's okay. In your contract documents, does the upstream contractor have an obligation, a written commitment, to pursue claims for you in their name, or to allow you to pursue the claim in their name? So, for example, if you're on a project where the general contractor is Turner and you're doing work for a steel contractor, let's say it's Surveys, and you've got a claim Okay? You go to Surveys, and Surveys subcontract says, you know, you're limited to what we get on your behalf from the owner. You say, fine, let's pursue it as a dispute. Can we pursue the dispute in your name, Surveys, to Turner? And you go to Turner and you say to Turner, we want to pursue it in the name of not only Surveys, but Turner with the owner. Give us authorization. Now, many times they'll say no, but I see more and more in these general contractors' standard provisions language that gives the option to the subcontractor to either have the general contractor pursue the claim for their benefit or for the subcontractor to be authorized to pursue the claim against the owner in the name of the general contractor. I can tell you which way I'd rather have it. I'd rather have my hands on the steering wheel if I'm the steel contractor or if I'm the erector, as opposed to just being at the, you know, another passenger on the bus. Liquidation agreements. What is a liquidation agreement? When you have a claim on a project, the general contractor, as part of their process of trying to avoid liability for having ever touched the project, they'll say, we're happy to pursue your claim with the owner, but we want you to sign an agreement first. And in this agreement, what we want you to do is to agree, number one, that you're giving us a release from any liability whatsoever for this claim issue. Number two, you're agreeing that you're going to pay us up front the cost of pursuing the claim. And guess what? It's going to agree that their cost of pursuing the claim come off the top. They get paid 100%, and then the claim proceeds that are left get distributed in some fashion. Well, the question is, do you have to enter into a liquidation agreement? I would argue that, not argue, I will tell you that in virtually all of these general contractor standard form agreements, there is no requirement for you to enter into a liquidation agreement, okay? The most that you'll find is a requirement that you indemnify them or hold them harmless from any counterclaim by the owner for a defective pricing claim that the owner may have because you've done some shenanigans with your claim. But my point is, you don't have to agree to a liquidation agreement in order for the contractor who's upstream to have the obligation to pursue recovery of your claim. If they refuse to pursue it, then they're essentially waving the shield that they have of independent liability. Okay, you with me? So my advice is never enter into a liquidation agreement if possible. Avoid it. If you're going to enter into a liquidation agreement, see if you can get them to pay for a portion of your claim up front as part of the process. Okay, let's talk for a few minutes about retention and final payment. These concepts are pretty straightforward, but it amazes me how people overlook them. How many of you review the owner-contractor agreement to identify what's the percentage of retention the owner's withholding? Okay, is it 10%, 5%, or 0%? Is it 10% until 50% complete and then it's reduced to 5% or 0%? I can guarantee you that in your standard form subcontracts, most of them say 10%. And if you agree to that, then guess what? You've agreed to something different than what's in the upstream contract documents. If your subcontract says 10% retention and you're doing work on a public project in Virginia, is that permissible? See, Art Williams back there shaking his head no, and that's, Art's right. Because in public projects in Virginia, there's a cap of 5% retention that the owner can withhold, and the statute expressly states that that cap is applicable to subcontracts as well. So the point is, know the law in the state where you're working and find out whether or not there's any statutory cap on retention for the type of project that you're working. Does the contract between the owner and the contractor have any provision for early release of retention? There's quite a few of these contract documents that actually do. But if you don't know it, how can you ask for it? Now, typically, early release of retention by the owner is discretionary, and it's not going to happen unless you kick the general contractor in the shins and say, hey, will you request release of retention for the steel? So submit a written request to avail yourself of the opportunity for early release of retention. Here's a basic, it's an AIA contract provision in the general conditions. It says that the owner and the contractor shall agree upon a mutually acceptable procedure for review and approval of payment and potential early release of retention for the subcontractors. Okay? Potential early release. If it's there and the owner knows it's there, why not ask for it? Here's one that's more specific. Retained will be released to subs on a line item basis within 60 days of final completion and approval of their work, including punch list work by owner, contractor, and architect. When a subcontractor completes 50% of their scope of work upon request and reasonable approval of the owner shall hold no further retainage from the contractor on progress payments. Okay. Upon request of contractor, who's going to trigger the request by the contractor? It's got to be you. Okay. How do you know that these provisions exist unless you read the full contract? Substantial completion. It's a great event on a project. A lot of times, your contract documents provide for release of the vast majority of retention upon substantial completion. But we have this mindset of, oh, okay, I get my retainage upon final payment. Okay. Here's a provision that provides for retention release upon substantial completion where the owner's rep generates a punch list and a value of 150% is assigned to the value of any punch list work or defective work. And that's the value that's withheld from retention, but the balance of it's released. Now, what's the point? You have substantial completion. The architect generates a punch list. There's no steel on the punch list. Or if there's a steel item on the punch list, it's not the erector's problem, it's the fabricator's problem. You should be clamoring for the contractor to ask for your retainage to be released immediately. The owner's got an obligation to do it. I can tell you, I was involved in that project out in Las Vegas called City Center. And a provision similar to this was in the owner's contract with Perini. And Perini had a policy. They didn't request release of retention, and they had component projects as part of that city center development. Perini wouldn't ask for release of retention upon substantial completion unless there was a specific request made by the trade subcontractor. And I was talking with one of the guys from Perini, and I said, how many of the trade subcontractors asked for it? They said, about 3 or 4 on a component project typically. The ones that read the documents. The vast majority of them, they wait until final payment when the owner does final acceptance. Okay. Once again, you've got to push the contractor to honor the contract documents. And many times that means pushing the contractor to ask on your behalf for what the owner's committed. If the owner releases retention, and let's say that the owner has released all but 1% of the retention. So, owner's withholding 1% retention, and you're told, well, okay, you're going to get your retainage all except 1%. Well, what's the basis for the owner withholding 1% retention? It's typically tied to incomplete work. It's typically tied to punch list issues, right? If you don't have a dog in the hunt, you should not have your money held up. The contractor has mechanisms in their agreements with the parties at fault, the other trade contractors who screwed up, in the default provisions, to hold them accountable, to charge them the costs arising out of their failure to properly perform their work. So you've got to insist that you don't get just simply a pro rata payment if you're not at fault. Okay. You need to think about modifying your final payment provision to include the possibility that if non-payment by the owner is not your fault, you're going to get paid. Okay? The payment obligation should be clear. This is a provision from a steel contractor subcontract to an erector. Okay? Final payment should be made within 7 days after receipt by the contractor of final payment from the general contractor for the subcontract work. However, payment by the general contractor to the contractor is an express condition preceding the contractor's obligation to pay, and the sub agrees it's relying upon the credit of the general contractor for payment of this work. Aside from the fact that this pay if paid clause is not enforceable in about 30 states, we still have the mentality of people wanting to live by it. Okay? So why not modify that provision up front with your customer, the fabricator, by adding a provision that says, notwithstanding anything to the contrary, if non-payment to the contractor by the general contractor is not due to any fault or failure of performance by the sub, then the contractor may withhold payment for a reasonable period of time not to exceed 90 days. Okay? What is objectionable about that? If the fabricator says, no, I'm not willing to agree to that modification, what they're telling you is, I want to use your money to pay for my mistakes. In plain English, that's what they're saying. Now, you say, fine, I'm a nice guy, I'm a nice lady, I'll let you have it for up to 90 days. But if you can't get your stuff organized and get your problem solved within 90 days, that shouldn't be my fault. Okay? Now, one trend, this last point on final payment, and it has to do with disputes. I'm seeing more and more in general contractor subcontract agreements a provision where the subcontractor agrees that if payment hasn't been received from the owner for the subcontractor's work, then the subcontractor agrees to allow the general contractor a reasonable period of time, that's pay when paid, reasonable period of time in order to secure payment from the owner. And the provision defines a reasonable period of time as the time necessary for the general contractor to exhaust all of their legal remedies. Now, what does that mean? If you've got arbitration, well, they've got to go all the way through an arbitration. I'm involved in an arbitration on a project that was completed in 2008, and we're just having the preliminary hearings this month. Okay? If it's litigation, God help you. What does exhaustion of legal remedies mean? It means not only go to trial, but if the general contractor doesn't like the result, or the owner doesn't like the result and they want to appeal, then it's the exhaustion of an appeal. I was just on a project, it was a convention center project, that got settled in July of 2011, where the project was substantially complete in 2004. And that case was in litigation and hadn't gone to trial yet. It got settled in a mediation. That's 7 years, people. And they hadn't even gotten to the courthouse steps. Do not agree that exhaustion of legal remedies is a reasonable period of time. It's not, especially if you're not to blame for the delay in payment. Finally, even if you have this type of language in your subcontract, you need to remember, know the deadlines for filing liens and payment bond claims, and get those claims filed, okay? Those, the courts have consistently held that these contractual provisions cannot alter the statutory framework of liens or payment bond claims and the timetables in there, okay? If you're on a federal project, you have, and you're a second-tier subcontractor, you have to give the general contractor notice within 90 days of your completion of your work, right? And then you've only got 9 months after you give them notice in order to file your suit on their payment bond claim. Otherwise, you lose your right forever to go after their payment bond. So even if you have a provision that extends out this period of time for a while, get these payment bond claim notices filed in a timely manner, get the liens filed in a timely manner. Okay. The outlines give you some ideas. We've talked about some concepts, we've talked about some strategies. My point is, if you think about and actually implement some of these strategies, I believe that you will have an increased collection on changes, and you'll have a more timely payment of your release, of retention, and hopefully that should increase your profitability. It's in your hands. We go to these sessions, we get these great ideas, and then we get back to the office and we get caught up in the work. Please, take a few minutes and try and make a difference. Go and take a look at your change order log form and think about making some changes. I've never seen one of these forms that was chiseled in concrete. They're spreadsheets. They're made to be changed. Yes?
A couple of years ago in North Carolina, subcontractors lived in Seven Seal with North Carolina got some retainage reform on public work. At that time, the maximum on state work was 5%. That did not include things like municipalities. Change got made, it brought into municipalities. On the retainage portion, we got in there that any trade that completed their work by the time the overall project was 50% complete, our retainage would be released at that point. Then all the rest of the trades would be released at the end of the project, when the project was either substantially complete or occupied. We've had, at the time, we've all had jobs that they've occupied a building for 6 months before going into the thing. We got that legislation passed.
I mean, it sounds like some very valuable legislation on behalf of subcontractors. My point, as I indicated in the outline, is you have to know the law with regard to retention of the state you're working in. So if you don't currently, like, this gentleman knows the law of North Carolina pretty well. You have to ask for it. There's a lot of stuff that you have to ask for. I commend you to become more assertive, okay? An unresolved change is a disputed change, okay? Remember that. Push these changes. If you don't, nobody else will. Anybody else have any other questions? Yes? Right. 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 Okay, now, in that situation, the gatekeeper, the architect, or the engineer, they've got an incentive to make you go away because they don't want to have to be accountable to the owner for possibly causing additional cost. If you let them, they'll sit on that until the end of the job. And guess what? It gets lost in the mix, the horse trading at the end of the job. But if you push the architect and you say, you know what? I hear what you're saying. I disagree. The contract has a mechanism for us to resolve disputes. Let's go ahead and let's go ahead and get a written decision from you on this claim. Then if you get a written decision in many of these contracts, the next step is to go to a mediation. Okay? I mean, it might have several layers before you actually go to court. But the point is, getting it off high center is treating it as a dispute and asking for a written decision.